So we've talked about offer. Now we turn to acceptance. How do we know when an acceptance has been made? There is an offer on the table. The offer is sufficiently definite and indicates an intention to be bound. How do we know when acceptance occurs? Again, knowing when acceptance occurs is important because that's when the contract comes into existence, when offer and acceptance have been made. Well, CISG Article 18 says that a statement made by an offeree can indicate an acceptance. If the statement indicates assent to the offer, there is acceptance. Furthermore, if there is not express acceptance, but there is conduct that indicates acceptance, then again, acceptance has been made. Once there is offer and acceptance, we have mutual assent comes into play, and therefore the elements of a contract are present. Now, silence itself is not enough to constitute an acceptance. Offeree who's silent on an offer cannot accept the offer merely by silence. If the seller makes an offer and says, well, if you don't hear from me, then I'll accept the offer, well, that's probably enough to rise to the level. But ordinarily, silence cannot constitute an acceptance. Now, when is acceptance effective? You may remember from your legal studies course, your introductory legal studies course, this notion of the mailbox rule. The mailbox rule. And what the mailbox rule says that under the common law, and under the UCC as well, acceptance is valid on dispatch. We call it the mailbox rule because the idea is when a offeree puts his acceptance in the mail, then acceptance is valid and a contract has come into existence. Even if the offeror revokes his offer after the dispatch of the acceptance, but before it's been received by the offerors cannot revoke the offer. His revocation is ineffective because acceptance occurred on dispatch. The contract was formed when the acceptance was put in the mail. And obviously, with modern technology, the same rule applies. When I send the email accepting the offer, that is when acceptance takes place. It's not when the person receives the email or reads the email for the first time. It's when I sent the email, when I send a fax, when I send a text. In any of those cases, the acceptance becomes effective as soon as I send it on dispatch, and therefore the contract comes into existence. Now, according to the CISG, this is different. Article 18 of the CISG says that acceptance is not effective on dispatch, but instead is effective on receipt, meaning acceptance doesn't become valid until we establish that the offeror has received the acceptance. Therefore, under the CISG, if the offeree sends an acceptance indicating assent to the offer, the offeror is still not bound. Offeror retains the right to revoke that offer as long as that it has not received notice of the acceptance. So the mailbox rule under the CISG works exactly opposite of the way it worked under the common law. Now, the last thing we'll look at, the last issue that comes up, is what's known as the mirror image rule. Now, under the common law, an acceptance is only an acceptance if it mirrors the offer. It must exactly match the offer. If there is any term that differs between the acceptance and the offer, then under the common law, it's not an acceptance. Instead, it becomes a rejection of the offer and a counter offer. The first offer is dead, and instead, the purported acceptance is in fact to be construed as a counter offer. So there's a possibility that the contract does not exist. Now, under the UCC, they did away with the strict mirror image rule. Under the UCC, the law holds that if most of the acceptance and the offer match, then it is an acceptance. And the terms of the contract are going to be those that the parties agreed to. So if someone put a bunch of new conditions into the acceptance or changed the wording of the acceptance, it's still going to be an acceptance, but it's going to be an acceptance based on the original offer. So there's much more latitude in the ability to make an acceptance under the UCC. This is not true for the CISG. In this case, the CISG mimics the common law. And the CISG says a reply to an offer which purports to be an acceptance but contains additions or limitations or modifications is a rejection of the offer and instead is a counter offer. So under the CISG, the mirror image rule still applies, and there is no contract formed, even though they use terms like, yes, I agree to the terms of the contract, except I want to modify delivery by 1 month. That's not an acceptance under the CISG. Instead, that's a rejection of the offer and acceptance and the making of a counter offer. Under the UCC, the law wants to find a contract. The law encourages the finding of a contract. Under the CISG, it's not the same. Under the CISG, they would not form a contract on that basis. Now, in international transactions, in fact, in most sales transactions, the parties tend to use standard forms, standard business forms. We've already talked about the pro forma invoice as a standard business form. Now, the problem with standard business forms is that each party is likely to use its own form. And those forms will often contain what we call boilerplate, which means a lengthy list of terms and conditions that are attached to a business form that have nothing to do with the actual substance of the sale, but which can govern things like delivery date, payment expectations, arbitration agreements, mediation agreements, any number of extraneous issues could be set out in the terms and conditions attached to these business forms. And so what will occur sometimes is one party will make an offer using one business form. The other party the offeree will then accept the offer using its own business form, and then we will have this problem of conflicting conditions. Now, what are the business forms that are most commonly used? We already mentioned the pro forma invoice. Now, the next one that is likely to be prepared by a buyer after the seller has delivered the pro forma invoice is what's known as a purchase order. And a purchase order is a commercial document that's issued by the buyer to the seller, indicating the type, the quality, the agreed price for the products or services that the seller is going to provide to the buyer. And again, I'll have a copy of a purchase order up on the D2L for you. Now, once a seller receives a purchase order, the seller will often prepare what's called an order confirmation. And this is a document confirming the purchase order, the terms and conditions of the sale may be included in this order confirmation. Those terms and conditions can differ from what the buyer listed in his purchase order. So what we have here is a problem that in the law we call a battle of the forms. A battle of the forms. Now, under the common law, if a seller sends a confirmation in response to a buyer's purchase order, and the seller's form contains different or additional terms, then no contract exists. That fails the mirror image rule, and no contract exists. Now, under the UCC, a written confirmation that's sent within a reasonable time after receipt of the purchase order, even if it contains additional terms or modifications that are different from those in the purchase order, unless the confirmation is expressly made conditional on acceptance of those terms, the contract comes into existence, and the contract is based on the original offer's terms. So under the UCC, there would be an acceptance of the offer, and the terms of the sale will be that which were found in the purchase order, unless the offeree has expressly made his acceptance conditional on acceptance of the additional terms. Now, the CISG, I told you that it follows the mirror image rule. However, from a realistic perspective, the CISG understands that people use business forms and the business forms conflict, and sometimes that can present a problem. And so what the CISG does is attempt to walk a line in between the common law, which would find that contracts do not come into existence, and the UCC, which would almost certainly find that there was a contract there. So under the CISG, an acceptance containing new terms, as long as they don't materially alter the terms of the offer, become a part of the contract, unless the offeror promptly objects to the change. So the terms and conditions in the offer, in the seller's confirmation, those will become the terms of the contract unless the buyer objects to those terms, additional or changed terms. Our last topic we're going to look at is standard contract terms and the validity of standard contract terms. Now, in this case, we're going to talk about a standard set of terms called the Incoterms, I-N-C-O-T-E-R-M-S. Now, the Incoterms are a set of standard contract terms that were published, or that are published, by the International Chamber of Commerce in Paris. And what the Chamber of Commerce has done is issued a set of common contractual provisions, and the parties to a contract can use these terms with the understanding that all the parties will understand what the terms mean. These terms are standardized, and therefore they are held to have a standard meaning regardless of the parties that use them, regardless of the type of sale it was, whether it was a small sale or a large sale. If the parties use these standard terms, the Incoterms, then those terms are going to be governed by the standard meaning of the terms. Now, we have a number of common abbreviations, and we'll talk more about these when we talk about the documentary sale. But some that you will see are often known as, there are always three-letter abbreviations. So the first one is FAS, which stands for free alongside ship. In this case, the seller has cleared the goods for export and delivers them. Delivery is said to take place when they are placed alongside the vessel at the named port of shipment. Another common term is FOB, free on board. In this case, the seller clears the goods for export, and they are said to be delivered when they are placed on board of the vessel at the named port of shipment. The buyer then assumes all the risks and the cost associated from that moment forward. Another common term is CFR, cost and freight, in which the seller agrees to pay the cost and freight associated with the transport of the goods. A related one is cost, insurance, and freight, meaning the seller will provide, not only pay the cost of the transport, but the seller will also provide insurance on the goods that are going to be transported. We'll talk more about Incoterms when we talk about risk of loss and how the sale actually works, but understand that these are standard contract terms and parties can use these terms, and the parties will know what the terms mean as a result of the standard interpretation of those terms. And that's it. Thank you.